collector, the more money I can collect for you. It's just, you got to sell them on the idea that they're going to have to do a little bit more maybe than they've been doing in the past to help you help them. I mean, that's the theory. Help me help you. And some of the issues, one of the issues that I've seen in my litigation practice is that to start looking at some specifics is naming. How do you identify who the debts are owed to? When it's a hospital, let's say it's an operation, you've got multiple, you've got an anesthesiologist, you've got an attending, you've got a surgeon, you've got multiple parties that took part in that operation. And how do you break that out? And how do you identify them? Do you identify by each individual? Do you identify it by the hospital, the date of the operation, and kind of then, I guess in paren, ABC Hospital, Dr. Jones, anesthesiologist. ABC Hospital, Dr. Smith, surgeon, on that letter. Break it out. The other issue is when you've got small practice groups, doctors groups. And how do you identify them? And sometimes their legal name may not be the best method to identify that doctor's group. And the regulations allow you to use a name that the debt will recognize. I believe it is paragraph 34C, paren C, close paren 2, close paren V. The validation information includes the name of the creditor to whom the debt is currently owed. A debt collector may disclose this creditor's trade or doing business as name instead of its legal name. I know of one particular doctor's group that when I looked at their bill the first time, I said, I don't understand who this is. It makes no sense to me. And it wasn't until I looked them up and I saw, yeah, sure enough, that's the name. That's the medical group. But the name gave you no indication. It was gibberish. No other way to put it. So of course the debtors didn't recognize it. What are your thoughts?
Well, Mitch, I think you're right. And I think if you're looking at how to approach this, I think the appropriate way to do it is work backwards. Figure out what you want to have on that model validation notice. Again, that's going to reduce that consumer, that patient confusion, and then work backwards and make sure you're getting that information from your clients, whether it's the facility name, if that's easier, if it's the practice group, whatever that is. And then, but the issue I think you're going to have, and I think many agencies are having, not to kind of reiterate things, is that, within healthcare, it ranges from, big hospital systems where, agencies have tried to partner with their clients before, and they really don't get much, headway. It took the industry about 5 years to get TCPA consent language. In most healthcare providers, it just takes a long time to get that upstream because, what we don't realize, because collections is everything in our industry, is that, self-pay bad debt collections is 1/10 of a sliver of an overall hospital system's revenue. So it's not going to move the needle much generally to make a change and try to work with your clients on that. But I think, we've got time. The good news is now, and absolutely we should be, I think a good plan of action is for an agency to kind of identify the data points they want to put on their letter, and then to work upstream now with their clients to be able to start having those conversations and get that information to be able to be compliant with that.
One suggestion that comes to my mind is trying perhaps, especially with the larger entities, if you've got IT people in your office and your agency, if you've got an IT person, that you go and try to set up a meeting with their IT person to see if you can better, work the information so that you can make that marriage, you can make the two meet. I think that's an important point that maybe people haven't thought about. But you don't want to talk to their collection manager. You want to talk to their IT person, because that's the person who's responsible for transmitting that information. that information to you. So that's something to consider, certainly with the bigger agencies and the bigger medical groups. But even if it's a small medical group, you've got somebody that you use, whether in-house or out-house, that you can go meet with them and show them how they can do it. That just might grease the wheels a little to getting it done.
It's a double-edged sword, and you want to be careful, I suppose, about flagging lawsuits to your clients, right? That's not necessarily a thing you always want to advertise, lest it be viewed as some kind of compliance gap or failure on your part. But it's been my experience that if you can point out to them that we've learned this lesson the hard way, that this has come up in a lawsuit, that may actually get their attention. Like you're saying, Heath, it's only a tenth of a sliver, right? So how do we get that needle to move? Litigation that's filed tends to get people's attention. And if you go back and say, okay, this is a somewhat expensive compliance lesson, how can we work on that? And obviously we don't have anything under Regulation F right now, but it wouldn't even have to be your lawsuits, right? If you can flag these types of issues, because they exist, right? We're all defending the creditor name issue, and it tends to come up most frequently with medical debt. So if you can take that back to your client and say, no, really, this is a thing, and we should be paying attention, because if I can reduce my litigation costs and my compliance spend and all that, I can be more efficient, and I can be paying more attention to, people on the floor and actually generating some collection revenue.
And Patrick, to take that one step further, I have cases where they're calling the hospital becomes a party. They may not be a defendant, but they're going to get called as a witness. I've been in a case where I've had to procure affidavits. They've been deposed. Do they really want to do that if they can avoid it?
Yep.
And there's a reputational issue. Do they want to be named? Not as parties, but just named, be involved. Do they really want to have that kind of issue? So there's a lot of benefit to them. If they made the decision to send certain accounts out for collection to third-party collectors, then they've got to, there's more to that decision. Just saying, okay, just send it out and we'll, see what they collect. It just doesn't work that way anymore.
I'm just going to jump in here. I want to just hit the pause button briefly on the discussion, which has been great so far, and there's a lot of questions that are coming in. But I want to invite McKay Bird from TCN, the sponsor of today's webinar, to say a few words. McKay.
Thank you, Mike, and as well as the rest of the panelists. This discussion would not be possible without you, Mike, and as well as Heath, Mitch, Patrick, for making this possible. But my name is McKay Bird. As Mike mentioned, I'm the marketing director here at TCN. But a little bit about TCN is we provide cost-effective call center solutions. We are an entire platform for the call center and specifically collection agencies. We have built-in data management and collection optimization tools for compliance. We have a very unique approach to our pricing model that supports scaling up or even down with no minimums or even maintenance fees, because we are 100% in the cloud. A few things that are built directly into our platform is we provide compliance and data management services, business intelligence with reporting dashboards, call recording with storage, smart IVR with payment capabilities, speech analysis with speech analytics, and so much more. And currently, right now, we are doing a promotion for our speech analytics tool and software that is built within our platform. And we are inviting any of those to take advantage of this 60-day promotion of our speech analytics software. We know that a lot of data comes in through these phone calls, and being able to make decisions, and not just on compliance, but as well as making sure that the agents are adhering to scripts, and as well as making sure customers are taken care of as well. So we'll post some more information about that promotion on our speech analytics platform. But again, give us a call or visit us at tcn.com for more information. Thanks, Mike.
Thank you, McKay. And thanks again to TCN for sponsoring today's webinar. I did just put a link in the chat window for you to click on to sign up for a demo for the speech analytics. So I encourage everybody to do that and check out what TCN has to offer. Looking through some of the questions that have come in, and so the next question I was going to ask, and Patrick, you alluded to it, and that's the rabbit hole of the itemization date. A lot of questions about which itemization date to choose, how to choose a date. Can you choose multiple itemization dates? So let's spend a little bit of time talking on that. And Heath, maybe you can sort of start us off by talking about why the itemization date is such an issue, and whether or not there's an easy solution or some guidance that you can provide to start with on how to choose which date to choose.
Sure. Yeah. I'm glad we're diving in here, because this is kind of the meat of some of the questions that we're gonna have today. And I'll preface my answer, and the rest of our answers will. It's going to be, it depends. There is no one size fits all answer here. And so it's going to depend on your clients, the information you're getting, on what you're choosing. But to kind of dive in a little bit on the itemization date, as we know, Reg F gives us a choice to list out a choice of 1 of 5 dates: the last statement date, the charge off date, the last payment date, the transaction date, or the judgment date. And one of those 5 dates has to be on that model validation letter. And once you pick one of those dates, you have to use it consistently with every communication and correspondence you have with that consumer. So if you've got follow-up letters, you want to use that same date. If you're making phone calls and you have people calling in, you want to make sure you have that itemization date you're using populated on your collector screen somewhere to reference that same date. Again, the goal here is to prevent consumer confusion. And that's where I think agencies are looking at, okay, let's make sure it's consistent. If we're getting this as a second placement from another agency, we're using the same date. Now, the other caveat we have here with itemization date is that last charge-off date, because as most agencies who collect on medical debt know, we don't always get that charge-off date from our client. And a lot of times the agency is essentially coming up with that charge-off date on their own. And so again, that's where agencies are concerned. Can we still use this date if we haven't gotten that directive from our clients? And that's where I would say, if that's you, I would definitely communicate and get some sort of writing agreement on what you're using for the charge-off date. Because and why the charge-off date is important is I would say that if you are credit reporting and if you're reporting on medical debts, you're using that charge-off date in your credit reporting function. So if you're looking to eliminate consumer confusion, it's a best practice. To me, it seems logical to use that same date that you're using when you're reporting an account. So a consumer who gets a letter and they check their credit report, they have matching dates, matching balances. That's going to reduce that consumer confusion. So if you're credit reporting, I think the overwhelmingly way to do it is use that same date you're using to report the account and that last charge-off date. If you're not credit reporting, then you go back to that choice of 5 and what information are you getting consistently from your clients that you can rely on to be using as a date moving forward. I probably opened up a lot more questions with that answer, but let's just get things started with that answer so far.
You wouldn't be a good lawyer if you didn't.
So
go ahead, Mitch. Sorry.
no, I was going to say I have a fairly strong feeling in medical debt. It seems to me the best date to use would be the transaction date, the date of service, because the whole idea is to make the consumer acknowledge or the debt, or what the debt is, what the charge is for. While they may not remember the last time they paid it, they'll certainly should remember when they were treated, and that's consistent. And if you choose that, and that's information that you should always have. If you don't have the date of treatment, you shouldn't be sending out, I mean, in my mind at least, you shouldn't be sending out notices because you really can't identify the debt accurately. So that would be my take. I think the other thing is that once you do decide on a date, that's consistent, and the more consistent, certainly it should be consistent among particular providers, particular your clients. You may want to change the date from client to client, but you shouldn't be using multiple itemization dates for the same client. That'll just get confusing for you, as a collector, your shop.
Yeah, that's Keith. Yeah, I think we did open up a couple cans. I was going to say initially for those keeping track at home, we're in the consistency bucket. If we're trying to make my metaphor fit here, I don't know if it'll carry the day, but your point about clarity too is avoiding confusion is ultimately what you want, right? Both in complying in the law and practically, if you have consumers that are not confused, more likely to pay, less likely to sue. So that's a win, right? Mitch, I think I tend to agree with you that the transaction date makes some sense if it's feasible. If you're getting that information, like Heath said, consistently from your client. There is also an added benefit there in the official interpretations from the Bureau, right in the rule, about multiple transaction dates. I know some people have been vexed about this idea that there could be multiple dates of service all related to a single medical issue. And, and let's open a new can. If we're noticing each individual account or date of service individually, this isn't so much of an issue. But if you're trying to do a consolidated validation notice, then which transaction date, which date of service are you going to pick? And the rule helpfully says you can actually pick any of them, right? As long as you do so consistently. And actually, if I can just ask a sub question, as long as I'm blowing up my own framework here.
Yeah.
I've heard differing opinions about, so let's play that out. There's a cumulative validation notice regarding a number of dates of service. Do you think it better to pick the first date of service as your itemization date or the most recent?
So there's two issues. There's the operation, which is easy because all the different doctors and et cetera, all happened on the same date. But then there's that you've got continuing service. And another issue, I'll throw in another question. You send out, Mr. Jones has gone to the doctor. He didn't pay. They sent out a bill. He then goes to the doctor another time and he doesn't pay that. And then they say that same doctor, same recurring issue. Do they send out a new notice? Do they add that to how do you deal with that next one? I think you send out a new notice and then you've got two lines instead of one in that regard to identify the old debt, to take account and show this is why the number is now increased because of the new charge that's been added to that. I think it's a big mistake to just send out your next letter with a higher amount. That's a problem. But that's a recurring problem with medical because they continue to, it's not like a credit card. They charge it off and you can't use it anymore. That's it. It's done. It's static. Medical, it seems to be changing. That bill will grow over time because they don't stop the account. They continue servicing the patient. So
yeah, I think Patrick, to kind of dive into your can of worms here that you opened up here, but it's the reason people are here today because they want to figure out they've got multiple medical accounts that are low balance and they want to figure out ways to put them on one letter. And so the initial caveat that we're operating under is that, the model validation notice asks for one account per letter. It does not, it lets you do other accounts, but the question is, do you break them out on an itemization on the back page or a separate page? And then you kind of, migrate away from that safe harbor. So when you're doing that, and we're looking at ways to do that, I think if you're listing multiple accounts, you are going to be better off listing a data service with each of those accounts to, again, avoid that consumer confusion. If you're using one date, that might, and it's actually different dates of service, you might add that, it might confuse the consumer. So if you are going to list out multiple accounts on the back page or on a separate page, you I think as much information as you can have, including an individual date for each of those services, are going to help reduce that consumer confusion.
And
You
there's
think-
good,
Oh, I'm sorry, Mitch. Go ahead.
there's good news. Paragraph 34C2(8)(3) says you can have a separate page.
Yep.
So you don't have to, this conundrum of how do I fit this stuff on one page? Forget it. All you need to fit on that first page is see the enclosed separate page for an itemization of the debt. And that's quote right out of the rule. So you've got that built in. I know some people have asked that question. That's the easy answer for how to do it. Or in terms of not trying to fit a square peg in a round hole.
Exactly. And so I guess if you're setting up a risk continuum, I'm curious what you guys think. Am I over here on least risk is I do one account per letter that matches up right with the model notice without the separate pages? Because I appreciate that there's a separate pages specific part of the rule, and that's great. But it is true that the further you migrate away, as Heath said, from the model, you have a question of now, are we in substantially similar territory? And it's the question then becomes for you, and there's a term of art in here that I'm sure I'll forget, but is the information provided in the same type of sequence and logic that the model notice provides? So I think there's at least a potential there for confusion, even though it's specifically contemplated by the rule. So if I'm setting it up, I'm thinking least risk, but most cost is individual letters. And then next over is, okay, separate page, some kind of matrix that gets all of your data in there. And then that saves you some postage potentially. And then hopefully we'll have a chance before we're done to talk about how does the emailed validation notice play into that? Can you accomplish all of your goals, compliance and cost wise?
Yeah, Patrick, to add to that, I think, when you're looking, obviously, if you're I think that if we're looking at itemization on the back page versus a separate page, I think you're closer in line with the safe harbor to have a separate page. I think when you look at the language of the rule talking about clear and conspicuous, I think the argument's going to be there to have a separate page be better. But to your point, Patrick, if you're mailing out 2 pages, you're doubling your postage costs right there. And so whatever, if you're itemizing just 2 accounts, does it make sense to just have 1 account per 1 letter, right? And then we're not even talking about the dispute part of it, in which, once you include all those accounts on a 1 letter and they send it its dispute back, what account does that dispute apply to? And that's the other aspects of things too. So again, if you're looking internally, the numbers that you should be looking at are how many accounts that you have are just 2 accounts. Because if you have 1 consumer getting 2 accounts, so you're sending out 1 letter for 2 accounts, it may make sense to send off, 2 separate letters than to just, have, both letters included in 1. If you've got, multiple accounts, 5, 6, 7, then you're going to see some more economies of scale. You also want to look at your dispute rates and the numbers of itemized statements that you're sending out on disputes, because if you get a consumer checking that box and just sending it back to you, and you've got multiple accounts, then I think you've got an argument. You got to send an itemized statement on all those accounts, because you can't differentiate which account the consumer might be disputing it for. So I agree with your premise that if you're looking at it, a best practice is to have kind of a 1 account per 1 letter. But obviously in our medical field, we know we've got lots of accounts with multiple low balances. The economies aren't there. So you really have to get a line of sight on what your internal numbers are, because this is where it's going to depend on each agency, each medical client. Your dispute rate is going to change how you want to proceed and bundling those accounts together.
That's why I like Heath. He's a data guy, right? He's not making any of this up. He wants to see the facts.
With regards to using the date of service, there's a number of questions that have come in, a couple about insurance and insurance paying after the date of service and how that affects using the date. And one question, which is sort of, I guess, technically it's not really a debt on the date of service. It's not sort of a debt until after that. Is that something that could be a potential issue? Does anyone want to tackle either of those?
Well, I'll jump in real quickly. I think because transaction date is listed as one of the 5 elements, I think you're okay using that data service as a transaction date. Now, what you didn't ask and what opens another can of worms is on that model validation notice is the amount of payments made on the account prior to the assignment to the agency. And, you know, the question that agencies are also asking are, does that apply to just self-payments, direct payments from the patient, or does that also include insurance payments? And and the answer is, again, we're not going to have clarity on this until we get litigation, moving forward on this, and the courts kind of resolve what that means. But I think those are the conversations that you want to start having also with your clients on what payment information you're getting from your client that you're able to include on that model validation notice that you can list out there. And again, be consistent, and it's going to be a payment that the consumer can identify. Again, all of this on the model notice is supposed to give more information to the consumer so they can identify, and recognize that account. So, that's the account I made a $500 payment on. I remember it now. Now I'll pay it. I'll pay the rest of it. So you're wanting to take that approach of what payments that you're going to, put on that field that are going to help the consumer identify that account.
So I'm going to assume, and maybe I'm wrong, but that those debts, the insurance, any insurance payments are taken into account before it goes out to collection, so that the amount of the debt has already taken into account any prior the insurance payments and any self-pay payments. I think that the transaction date is a point of identity. It's to identify the date of service identifies the transaction. Identifies the service. The amount of the debt, the date of the debt, when that amount was came into play is a different date, certainly. Since the operation was January 1st, insurance payment came in February 1st, and the letter's going out March 3rd. What's the amount of the debt? That's the March 3rd date. That's the date of the debt itself. What's the amount due? The balance on that date. That's a different date than the service date. And identifying that as balance still due. How do you, after giving credits and pay to payments and what other credits there might be? So am I confusing that or making that?
I don't think you're confusing it. I think it's just confusing in its nature. But I think you're on the right track, Mitch, in that you want to make sure that it's a best practice not to get into the logistics of insurance payments and adjustments.
Right.
So whatever balance that's being assigned to you for collection has already had that processed. And then you're picking a date, again, that's going to give the consumer familiarity with that. So I think you're on the right track. I just think it's confusing, and it's going to depend again on each client and each agency and what data they're getting.
When I was in law school, my civil procedure professor, if you'd ever raise your hand to ask a question, would stop you almost immediately and say, "You got a rule for me? You got a rule for me?" He always wanted the cite. And so foolishly, I'm going to now walk out onto a limb that I'm pretty sure is going to snap because I don't have a cite for you. I'm reasonably certain that either in the amount of the debt piece of this, or even the itemization debt or itemization date commentary or interpretation there, it does speak to payments by a third party and how that fits in and might be considered. Again, I don't have a cite for you, but if I'm not losing my mind, that exists in the rule. So something to consider.
So, it's 34C2-9, the current amount of the debt.
Mitch has a rule for me.
You want a rule? I'll give you a rule.
He didn't put his hand up though.
Okay. And if you've got current, and it goes on in paragraph 2, A debt collector who combines multiple debts on a single validation notice complies with 106.34 by disclosing on the validation notice a single cumulative figure that is the sum of the current amount of all the debts. I haven't been drinking, believe it or not.
Cumulative.
Cumulative, correct.
Okay. I'm trying to wade through the questions, of which there are a couple. Make sure we get to the ones we need to get to. Let's see here. Does the itemization on the separate page need to follow the format on the front of the model validation model validation letter? Or can it simply be a listing similar to an Excel spreadsheet?
I think it has to be similar to an Excel spreadsheet. I don't think it's conducive to the model letter, the way it's set up in the model letter. What do you guys think?
Yeah, I think what you're going to want to, again, add that clarity to the patient and whatever, because here's the reality of it is, safe harbor or no safe harbor, there's going to be lawsuits on the model validation notice, and each court in each state is going to set what is permissible. And what you're going to want is you're going to want a breakdown that you can defend as helping the consumer, that's not, confusing to the least sophisticated consumer. And I think, a breakdown in a more of a itemized Excel format is going to be much clearer than trying to copy all of the language that, you could leave in and leave out on that model validation letter.
Bingo. From my perspective, that's take home point number 2, is anything you can take in to a court from an optics perspective and say, this plaintiff ironically is complaining about information that was too easily understood or too logically laid out. And a point that occurs to me now is not that you would want to use it as a one-to-one template, but consider, does your provider client have a way that they set up multiple accounts that they relay to their patients? Perhaps a model for you to follow. Very difficult for them to say that they would have understood it coming from the creditor and then magically not from the debt collector.
That's a great suggestion.
Yeah.
Another question. What if a client sends over multiple dates of service for a consumer in one account? If we enter each date of service separately, the consumer will likely have 5 or 6 times reported on their credit rather than a single medical debt for that particular client. Is this going to be an issue? I'm going to say yes, but I'll let you confirm it.
It is an issue, and I think that's the perfect scenario to where, if at all possible, there's a way to list that as one account and combine those, if it's the same data service, to try to bundle those as one account. One, you're going to have easier clarity, and 2, not to follow Patrick's model here, but there is case law and a parallel argument of credit reporting, where if you are credit reporting multiple accounts with same data service, it actually helps the consumer to bundle those all as one account and report them as a one account versus itemization out and reporting them as 10 different accounts on a credit bureau. So I think if you have a way to communicate and work with your client to be able to take multiple, same data service, 6 different accounts, they hopped around as one account, you're going to save yourself and the consumer a lot of confusion.
So does anybody think it's a good idea to have language in that letter stating something to the effect of, for more information or for more details, please contact us when you do that?
I think that's standard. That's common language in a lot of letters. I think you're going to want to make sure that doesn't, overshadow the validation, by contacting them, you're not overshadowing it. But yeah, I think if you're inviting the consumer to contact you to resolve the account, that's common language. I think that's fine to keep in there.
So I know it's common language, but I'm saying that there may be a heightened need for that call to get clarity in this context, in the context of medical debts, where you've got multiple accounts and they've been bundled bundled to give the consumer to give the consumer a second suggestion that they can get more details by calling in. And then the second part of that question is an agency has to have that information readily available for a call that does come in.
For all the defense, oh, I'm sorry, Mitch.
No, go.
For our defense counsel who's on the line, I think that's a thematic point that you might consider taking to the bench at every opportunity that you have from an educational perspective, is helping them understand that the real work in collections is not accomplished by these letters, and the notion that we're going to cram everything in there that a consumer would ever need to know absent a phone call is not consistent with reality and is actually not helpful to a consumer. If you end up sending them a notice that looks like a mortgage disclosure form under, whatever, like a TILA form, this is not helpful. It's that phone call where someone has the opportunity to ask questions and hopefully get the account resolved. So
You just committed a major sin, Patrick. You're expecting there to be common sense involved in this process.
Shame on me.
Yeah.
I'll think about that.
Here's a question, because the model validation notice includes an opportunity for people to dispute a debt. If you're listing multiple debts, do you need a box for each debt?
That was Heath. Heath, you already pinpointed this.
Yeah.
That's.
Yeah, I think to vary from the model validation letter and give multiple check boxes, I wouldn't mess with that. I would honor, if they check a box, I would honor that dispute for every account that you have included in that letter.
Okay. Okay, let's see here. I'm trying to work through some of the questions. Sometimes in medical debt, we see an increased adjustment, and I do not see a field for that on the validation notice. Should you add one? Would that be considered materially different?
Increased adjustment.
If I'm hearing correctly, I would say like a self-pay discount was given and then it was retracted later on and the balance was adjusted upwards. I would not vary and add that field on a model validation notice. I think that's ripe for a lawsuit. And I think we go back to similar to insurance payments and adjustments, try to get that balance after insurance, that self-pay balance that's going to be applied to you, and have that be the amount that you're listing on that model validation letter. I think the closer you can do that and working with your clients to get that actual post-adjusted balance, the better you're going to be.
Patrick, this went back to something you were talking about earlier, I think. Are you stating that if we now get an account for ABC Hospital and we state the amount due and the service date going forward, for Regulation F, are we going to have to state that this is from ABC Hospital for Dr. Smith? Do we have to get that detailed?
I'm not sure I understand the question.
Okay.
Frankly, I think the point I was trying to make, is once you pick whatever your transaction date is going to be, you need to stick with that. And I also think if you're going to identify the creditor in a particular way, whatever you decide on the first time around, and hopefully consistent with all of your account placements, continue that. I don't think the recommendation is to alter or vary that in any way. That I think is an absolute trap for litigation, confusion, all that good stuff.
Sorry. I think that was like 3 cans ago. Sorry.
Can I just say we missed a real opportunity here by not saying buckets of worms? I just want to, but it's too late.
So
Is it too late?
Too late.
Okay. All right. We'll stick with cans then. So let's see here. Where else? Some of these other questions. Am I missing? What am I missing here?
Well, as you're reading those questions,
Yeah.
I will say that a lot of these are going to be fact specific. And so a lot of our answers really are going to be, it depends. And if Mike, if you can save those questions, maybe we can type out the written responses to those, because there's going to be a bit more context in each question. But I do think maybe in the last 10 minutes, maybe we should pivot a little bit to email, as Patrick brought up earlier,
Sure.
and talk about how that can be a solution for some of these questions. Patrick, you want to start off here talking about what opportunities you think email can add to reduce this consumer confusion?
Yeah, I don't think anything I'm going to say is terribly novel or earth-shattering, but go back to the risk continuum we're talking about. If you can break out each one into its own notice, each account into its own notice, it's a discrete standalone deal. And I think the claims for confusion are substantially reduced. And if you can then provide that in an email, you've removed the cost barrier. In fact, you're doing better, frankly, than sending even a cumulative notice, because you've removed the postage. And I won't even go down to into the Hunstein implications of that today, but we'll, some other day. But so that's my general thought, is that if you can find a way to do that, where perhaps you are sending a group of emails to this person, they each, assuming you meet the rule, it seems like a perfect marriage to me. But I'm curious what you guys think on the nuance.
Well, I'll jump in. Oh, go ahead, Mitch.
I think it scares me sending emails on medical. That it just scares me for so many reasons that I think we all understand. It's too easily, it can be, too many other people can see it, unless you've got a prior permission, quite frankly, unless you've got prior understanding from a debtor that this is my email address where you can send this. Without that in writing, I wouldn't recommend anybody using email. I just think it's too easy to run afoul. And I could see lawsuits. My wife saw it, my brother saw it, my grandmother, somebody was in the room and they looked over my shoulder. If they open up their email at work, somebody walked by. It's just, I just see it as a landmine.
Well, I think that the True Accord v. Green case certainly gives a path to email. And, I know that email is more and more common, especially in the healthcare space. A lot of providers have that email consent language in their mission agreements. They have that email, if you have those controls in there and you have, accurate data transfer, then I think it does. Certainly there's a risk, and certainly we're going to see it'll flush out. There'll be more email cases as the years go on, and we'll get a clearer path to it. But I think if you're looking at your options, and if an agency has, they're 100% healthcare, and let's say 25% of their portfolio are multiple debts that we're talking about, and they're wanting to know how they do that, you're going to weigh the risks of sending that to email, and the benefits to email are you can avoid a lot of that confusion, because you're going to lay out and they can just keep scrolling down that list. There's no back page, there's no separate page to list out those accounts. They're all included in that email. You have the cost factor, so you're not paying that multiple letters, multiple envelopes, postage there for it. So agencies are going to weigh the ability to, email multiple accounts on that 25% bucket they have, versus, sending all their other accounts standard letter, so I think that's a real decision that agencies are going to be making, and look in terms of how to get that. And then, you can look at controls and, feedback and compliance to make sure there are no unauthorized third-party disclosure. But I think, certainly that's an avenue that agencies are going to be, risk and all, when you're measuring that risk, you're making the business decision in terms of the added cost of sending multiple envelopes and multiple letters for multiple accounts.
Yep. Yeah. As further proof that everything is related, we can tie this back to the initial conversation about talking with your client at the front end and game planning right now with them on this issue of, do we have email consent? And it ties in with the safe harbor for electronic communications, and that second method of did the consumer provide it to the creditor, and did the creditor then give the required goodbye notice. This is something, if you're going to be having that conversation and plan to rely on that as your consent mechanism, perfect time to be talking to the creditor about these additional issues. But yeah, undoubtedly, it's more risky, and it is going to have to be litigated, and nobody wants to carry the water on that because it's not a fun process. But I'm of the firm belief that the medical space is uniquely situated to benefit from the use of the emailed validation notice because of this multiple account issue. Because postage is a real expense. It could be a 6-figure plus deal for an agency. So really, I think it has to be navigated. Nobody wants to be the first, but it's a real business issue.
Well, and if it makes you feel better, Patrick, too, there's going to be lawsuits with this model validation notice and variations of it anyway. So you're going to get sued. Agencies are going to get sued, and case law is going to be developed one way or the other. It's just, what kind of cost, balancing business decision are you going to make in light of that risk?
And I'm sure, Patrick, you're willing to offer a discount to anybody that does use email.
Deep. Yes.
To your point, and Patrick, there was a question that came in, about multiple medical debts, and so, are consumers going to get upset if they receive 20 emails? Is that something, how would you recommend that get addressed?
I've been talking a lot. Mitch, do you want to field that?
Well, I'm anti-email, so I'm great.
Mitch is going to say, don't send the email.
No, I mean, so I suppose that if they've consented to contact via email, then multiple emails would be a lot safer than trying to cram everything into one, because that becomes a processing issue in terms of how you're processing those emails, how you're able to send them out. Is that going, if there's any kind of automation involved, it may be easier to send separate emails per client, as opposed to jamming them, multiple clients or multiple services into one email. So that, I think that's what's really going to control that, how the process is being used.
Can I speak to a hypothetical jury on this? Right.
Sure.
So, ladies and gentlemen of the jury, here's the plaintiff's email history and inbox history for the month of May 2021. They got approximately 86,000 emails, right? They're complaining about 10 that my client sent to them. That's a drop in the bucket. It's not going to hurt anybody. They're not inconvenienced in any way. This is not a real problem. Certainly, I think it's very different than 10 G notices going to a mailbox, right? Then somebody might say, gosh, I couldn't get my mail or something. So I just don't see it I'm not too worried about that. Somebody might get hacked off, but I don't think that's
No, not the volume, I think, because it's easy to sort in the email and it doesn't go anywhere and you can put it aside. I mean, we all get emails that we put aside and I'll look at it tomorrow or the next day, that particular grouping. So again, it's got to start and end. Do you have consent? Because it's also, I have a question, how effective it is, email. And
that's going to depend by agency and by, every hospital system has a different client base. There's rural hospitals, there's urban hospitals, but the clients I work with, definitely email and texting, they get high response rates for that. And I see more and more agencies moving in that direction because of the response rate. And again, it's consumer preference. And if the consumers are telling you that's how they want to communicate with you, that's the way that agencies are moving.
No, I think that's the best. That's the most important point, Heath. It depends on your clientele. It depends on your geographic area, what's conducive and what'll work. What will work in one part of the country may not work in another.
Well, unfortunately, our bucket has run out of time there. I'm using bucket again, Patrick. But I do want to thank you and Mitch and Heath for your time and your insights today. Not everybody who's watching doesn't see this, but the panelists do. I don't know how many questions came in, maybe 10,000, I don't know. There were a lot of questions that came in today, and they handled them, deftly and right sort of off the top of their head. So for that, guys, I really appreciate it. Thank you very much on behalf of everybody who watched and listened and is walking away with a little bit better understanding of how to comply with Regulation F with respect to medical debt. So thank you for that. I really appreciate it. Also want to thank TCN one last time for sponsoring today's webinar. Please go to www.tcn to learn more about the company. A link will pop up, or a window will pop up on your browser, giving you a chance to share your feedback on today's event. Please do so. And also any ideas you want to see covered in an upcoming webinar. Those are always helpful. We're back tomorrow because we went a whole day without talking about Hunstein. We're back tomorrow with another Hunstein webinar, looking at it from the collection agency perspective on how they're doing and adjusting. If you haven't signed up for that, there's a link in the events calendar on accountsrecovery.net. There are also links for all of the events coming up next week. So hopefully we'll see you back for that. Until then, thank you very much. Enjoy the rest of your day. Keith, Mitch, Patrick, thank you so much. Really appreciate it.
Thank you.
Thank you.
Thanks.
Take
Thanks,
care,
everyone.
everybody.